Now, members of the jury, further as to testimony, please remember, and I mentioned this to you before, and I do not wish to belabor the point, it is your recollection that controls, not counsel's, as they recounted their recollection of the evidence in their summations, nor indeed mine, as I may refer to the testimony in my charge as it continues. It is your recollection, and your recollection alone, that controls. Let me make one thing clear to you with regard to the testimony and of the witnesses, and that is the distinction between the testimony actually given at this trial and testimony made prior to the trial at some other time. You will recall the defendant's counsel examined one of the witnesses, Kenneth Drake, through the use of some testimony given at a prior proceeding. Now, such prior testimony made before you on an earlier occasion is not the legal equivalent of evidence you hear from the witness who testifies here. Such prior testimony is not affirmative evidence of guilt or negligence, or even of the facts in that prior testimony. It is what is called in the law hearsay. It is admitted solely to assist you in serving or weighing the credibility of that witness as to what he testified to before. In other words, how much weight shall I give to this witness to what he said here, bearing in mind that he either said something different on an earlier occasion or perhaps the same time as the case may be. I also advised you, which you've already been told, I'm sure you know by now, that if during the deliberations you desire any of the witness's testimony read back, please notify a court officer, and you will then be brought back into the courtroom, and the reporter will report it to you. You may, if you so desire, take in with you all of the exhibits that have been received in evidence and have them with you during your deliberations. I further charge you, members of the jury, that whenever you can consistently reconcile conflicting testimony, it is your duty to do so, because human experience has taught all of us that persons present at the same time at the same events do not and cannot possibly describe it in exactly the same way. But where you find any conflict in the testimony that cannot be reconciled by you, do not hesitate to cast aside from that which you believe to be exaggerated or incorrect or willfully perverted, and accept that which you believe to be correct and to be truthful. Now, let me direct your attention to the current crimes that are changed in the indictment. I read this indictment to you at the beginning, letting you read briefly now once more. Jurors, in this case, really the major issue, perhaps the sole issue, is the defendant, or did he not shoot and kill the deceased, in this case, one Kroll. There is not, as I see it, any controversy with regard to the fact that the deceased Kroll was shot and killed on the particular day in question at a particular locale. The only issue in the case I have set forth now before you. Now, you must use your common sense. How do you really weigh testimony of a witness? I don't know of any specific method that can be used which is better than the one you utilize every day in your everyday lives, for every day, every week, since you were able to reason, and I think you judge credibility that you may.
Actually, my stupid machine wasn't working.
Oh no? Well, why is that? See, don't use it on, well, you're using it on the job, but something like that could happen.
Write beware.
Huh?
You write beware.
All right, B-E and then W-A-I-R.